Hello everyone, this is James Pendergrass and I will be discussing a breach of contract and implied covenant of good faith case that was right here in Tennessee. This is for all you salespeople. Since chapter 6 and 7, or 7 through 9 this week, talks about the interpretation of different kinds of contracts, I thought this would be a good case to discuss. I've had a lot of experience with this sort of what happened to this guy, and it really hits home for me. I've been in sales roles all my life, whether it be management, outside sales, on the street, cold calling, straight commission, and a good portion of my pay has been through commissions. And I've been the recipient of a few what you would call shady deals, to where one in particular, I closed a big account, and then all of a sudden I didn't get paid what I was supposed to. So that's what this case is about. On researching this breach of contract case decided by the Court of Appeals of Tennessee, I learned two important lessons. One lesson is for sales representatives who are paid by commissions. The other is for the Tennessee lawyers that represent them, who handle the breach of contract cases. Sales representatives, if you don't obtain adequate protection for yourself in the written contract you sign before you start work, you should not be surprised if the company does not pay commissions for sales which you generated, and should not be surprised if they cannot be helped by the court. The lesson for lawyers in this sales commission case is the duty of good faith, which is implied in every contract in Tennessee, cannot rescue a sales representative, even one who's been treated unfairly, from a bad bargain which they made on the front ends. For 8 months after the commission agreement was signed, Schwartz traveled extensively, and it seemed like he was a hard worker and diligent to sell the medical test offered by Diagnostix. Schwartz made pitches to one particular organization, a very large customer, which had a big network and which could potentially result in many sales. Then Diagnostic bypassed Schwartz by entering into agreement for the purchase of the tests. So Diagnostic went over his head, went straight to the customer, so they actually get the deal, not him. Then they terminated the commission agreement with Schwartz. So he went out and sold all this stuff, and then now they're saying that, too bad, we're taking the customer. Although Diagnostic claimed that it had to terminate the agreement because the organization in question complained about Schwartz's aggressive sales tactics, it was reasonable to assume that Diagnostic stated reason for terminating the agreement with Schwartz was pretextual, and that it terminated him to avoid paying him commissions. Schwartz filed a breach of contract lawsuit against Diagnostic. He alleged that Diagnostic breached its duty of good faith by terminating him to avoid paying him the commissions. So Diagnostic filed a motion of summary judgment asking the court to dismiss the claim of breach of duty of good faith in the Davidson County Court here in Nashville, and the court actually granted Diagnostic's motion. Duty of good faith, chapter 16 discusses performance obligations and a corporation acting in good faith. And I've seen these in my contracts, act of good faith thing. Contract law, the implied covenant of good faith and fair dealing, is a general presumption that both parties to the contract would deal with each other honestly, fairly, and in good faith, so as not to destroy the right of the other party or parties to receive the benefits of the contract. So basically you're saying, hey, firing me and taking my commission definitely wasn't acting in good faith. So this is what his lawyer the angle the lawyer took. Schwartz did appeal the case, and the Court of Appeals agreed with the trial court that Diagnostic was entitled to a summary judgment on the breach of duty of good faith claim. The Court of Appeals pointed out that Schwartz had expressly agreed that he could be terminated without cause, and that if he was not entitled to any commission. So basically they're saying, hey, you signed the contract. Too bad for you. What Diagnostix did to Schwartz was unfair, but Schwartz had expressly agreed that it could do just that. So the Court of Appeals of Tennessee concluded that Diagnostic did not act in bad faith, or did not breach its duty to perform the contract in good faith. I don't know why either. The Schwartz case teaches us the duty of good faith cannot be used to throw out agreed upon contract terms, even if those contract terms do not conform with what a court would consider good faith, and even if those terms are harsh. In a perfect world, Schwartz should have seen at the onset, looked at the contract, noticed this stuff, maybe put in writing that he was allowed his commissions even if he was terminated, or some kind of caveat. There are many ways he could have maybe put something in the contract to where he wouldn't have gotten dinged like this. A provision that required him to be paid, even if he's terminated. What I think is that when you start a new job, you're going to sign anything. I mean, there's so much competition out there, and most of them give you this boilerplate contract. I know a lot of large companies use these, and you're not going to tell the guy, I'm not signing this unless you put this in if you really want the job, which, you don't go into a position thinking that the company is going to act in bad faith to you, or that, what am I going to do when I get fired? You're thinking, I'm going to, work as hard as I can, etc. This case goes to show the company has all the leverage, and the employee's basically at the mercy of whatever the company wants to do. All that you can do is do your due diligence when joining the company. Maybe talk to some people that currently work there. I know I did that a couple of times, or better yet, people that do not work there anymore, some past employees. Maybe you can get online and research it a little bit. But this case did hit close to home because I'm in sales, and those contracts are hard to break. So thank you.